Very often, when an employee starts working at a job, not just sexual harassment cases. Every worker deserves their day in court. These laws are there to protect you.
Where do you believe current laws fall short in protecting workers, especially marginalized groups?
So, a lot of these laws, for whatever reason, have limits on them. For example, Title VII, the Civil Rights Act of 1964, it applies only to employers that have 15 or more employees. What about all of the businesses that have less than 15 employees? Sure, there are state laws that apply, there are other federal laws that apply, but I think it's time to make some amendments to this because it's 2026 already. This was created in 1964, and the law really should apply to all employers, regardless of their size. An example of that would be Trafficking Victims Protection Act. It could be the Fair Labor Standards Act, the Race Discrimination 42 USC 1981. So that needs to be changed. Another example is as our gig economy has exploded, whether it be with rideshare, drivers, delivery workers, freelancers, they are entitled to as the same rights as people who are considered employees. Independent contractors should be given full federal anti-discrimination protection, and I don't know why they're not. Also, I see that arbitration is being forced upon employees when they have discrimination cases. Very often, when an employee starts working at a job, they sign a document saying, I agree to arbitrate all my cases. That means that if they want to bring a case for discrimination, let's say, they have to go before an arbitrator, not a judge and a jury in a courtroom, but basically a retired attorney who became an arbitrator who will be hearing this case, who hears these cases quite frequently and could be jaded or could even be leaning towards the employers. And it's generally, in my opinion, not fair to the employee to have them do that to take away their right to a jury. So I would like to see those arbitration agreements completely voided, not allowed in cases. We also have, just so you're aware, that Joe Biden signed something called the Ending Forced Arbitration in Sexual Harassment Cases Act a while ago. So if it is a sexual harassment case and you signed an arbitration agreement, that's void. You still get your right to go to trial and whatever. I'd also just like to see more rights for domestic workers, nannies, housekeepers, home care aides. And lastly, there is this concept, and we touched on it before, about severe and or pervasive. So generally throughout the entire United States, you can't sue unless something is severe and or pervasive. I don't think that should be the law. It should all be like what it is in New York, which is everything can be sued for as long as it's based on discriminatory, unequal treatment and it rises above something that's considered a petty slight or trivial inconvenience is the language that the court used.
Thank you. In relations to what you've just said now, what legal reforms are most urgently needed to prevent abuse and retaliation?
There are a few acts that are in play right now. Not laws yet, but these are pieces of legislation that hopefully will be passed. The first one is the FAIR Act, and that would prohibit forced arbitration in employment cases entirely, not just sexual harassment cases. Every worker deserves their day in court before a judge and jury, and arbitration agreements should not be required in those cases. There's another act. It's called the Be Heard Act. That's a comprehensive reform that says that all employers are responsible to comply with anti-discrimination laws regardless of their size. Whether they have 15 or more employees, 4 or more employees, all employers, period. That's what we were talking about before. And lastly, the Domestic Workers' Bill of Rights that would extend all of the employment law protections to all of the 2 million plus domestic workers who've been excluded for nearly a century in this concept.
Thank you. When you say domestic workers, are you referring to people who are domestic staff like nannies, drivers, gardeners, and so on and so forth?
That's exactly right. So a lot of the laws have been excluded to domestic workers. And the Domestic Workers Bill of Rights, if passed, would extend that protection to them, to the nannies, the caretakers, the au pairs, the home health aides. They would be entitled to those rights. And why shouldn't they be? They're working, they're employed, and as such, they should be fully protected under all of our laws. But however, that doesn't mean that they're not protected at all. It just means they're not protected under some laws, and that's not fair either.
Thank you. Actually, I do agree with you that it's not fair because they are paying taxes as well. So, what message of hope do you want survivors to walk away with today?
I'd like survivors to know that our justice system is here for you, that these laws were enacted for you, whether it be laws that came about as a result of the Me Too movement, as a result the Civil War, even. That's the Civil Rights Act of 1866. These laws are there to protect you, and they are to protect you from discrimination. And if you complain, they are there to protect you from being retaliated against. So take advantage of those laws. Know that you are protected, and if you engage in what's known as a protected activity, your employer could have the biggest part of your lawsuit against them because of that retaliation. So stand up, use your power, use your strength, and know that you don't have to be a victim anymore.
Thank you so much. I think that is very vital. So listeners, you've heard what Derek said. Make use of the law. So that leads me to this particular salient question. How can survivors protect themselves digitally, especially in countries where surveillance or employment control is common?
That's a really big concept these days. People are working from home. People are having their computers monitored, whether they be at the office or at home. Their company phones, laptops, and the technology has become so widespread and available that it's very easy for employers to see exactly what their employees are doing at all times, whether it be monitoring their keystrokes. In our office, we happen to have Microsoft Teams, and with Microsoft Teams, we all have access to all of the same apps, the same programs, and we have a great way of communicating with each other. But one of those features of Microsoft Teams is that your boss can always see at any given time for the past 6 months, for the past 3 months, past day, how many emails you sent out, how many calls you made throughout the entire day, if any, and all of your interactions and files and how many times you accessed your files. This is very important. When you are working for your company, your employer, your privacy is in large part out the window. Your boss does have the right to see what you're doing, how much work you're doing, and you don't have much protection there. However, just make sure to keep your personal stuff off of your employer's laptop, your employer's telephone, your cell phone that you're using. Know that for sure. Keep the two, the work phone, the work laptop, and the personal laptop and the personal phone should never meet. Keep them separate. That's my advice.
Thank you so much. I think that's very important because you can't be doing your personal business at the expense of your employers. It's costing them money as well. So we have to be morally upright when it comes to such matters. And we also have to put ourselves in their shoes. Be safe and be positive. And don't forget to check out our social media handles. Thank you. Bye for now.